Your company just got hit with a TTAB opposition. We're going to talk about how this works, how to fight it, and in the end, I'm going to give you some tips as to how to design a strategy to combat this opposition against your trademark. The first thing that you need to do as a business owner who's received a TTAB opposition is take a deep breath. While these oppositions are handled similar to a mini court case, this is not the same thing as being accused of some sort of violation of the law or something like that. The dispute of a TTAB opposition is that somebody else thinks that your trademarks will confuse the marketplace. So how do we get here? You've gone through the trademark application process at this point. Your trademark has been examined and you've gotten to the point where it's been published for opposition. Now this period lasts 30 days, and during that time, somebody's either filed an extension or they've filed the opposition directly against your application. One of the misnomers about trademark law is that it's pretty straightforward and simple. That can't be any further than the truth, because as you're finding out right now, the trademark law actually becomes very complicated very quickly. So somebody's filed an opposition against your trademark application. How do we handle this? Well, the proceeding is going to go in 6 steps: pleadings, discovery, summary judgment, trial, briefings, and then finally appeal. We're going to run through each of those steps quickly and what's involved at each step. So the first step, the pleading step, is where you're probably at if you just received an opposition and you're watching this video. The pleading step is where the opposer is going to serve what's called a notice of opposition against you. That is similar to a complaint in a civil lawsuit, because after all, the TTAB opposition functions as kind of like a mini lawsuit. You now have an obligation to respond with a responsive pleading. That's going to mean that you're going to need to answer it. You're going to need to potentially file a motion to dismiss. But once ultimately both sides have their pleadings on the table, that is when the case advances past the pleading stage and into the discovery stage. The discovery stage is going to proceed similar to a federal lawsuit. So you're going to have the process of having interrogatories, of having document requests, of having exchanges of information that are relevant to the case and able to share so that the parties can ultimately build their cases and decide what evidence needs to be presented at trial. Typically at the conclusion of the discovery phase, you want to think about summary judgment. This is where the case could be resolved early before getting to trial. At this point, you're having to construe facts using discovery and based on rules of construction, such as favoring the other party. But sometimes an early resolution at summary judgment is more advantageous than going through trial and through briefing in a TTAB case. The next phase along the way is the trial, and this is where we're going to diverge pretty significantly from what trial looks like in a typical federal civil lawsuit. At a typical federal trial, you're going to have parties that are present in the courtroom able to present evidence to the fact finder to make a determination as to what facts are and what facts are not. However, a TTAB opposition is going to proceed quite differently from that. While the rules are going to be similar as far as what can come in as evidence and what can't come in as evidence, a TTAB opposition is going to proceed asynchronously. What does this mean? This means that each party is going to have a window of time in which to submit their evidence to the TTAB electronically from your computer. You're not present in a courtroom for a trial. It's going to be submitted electronically via the internet. The order in which evidence goes in is pretty straightforward. So initially the opposer, or otherwise known as the plaintiff in the opposition, is going to be able to submit the evidence for their case in chief. They're going to have their first trial period, which is where they'll submit their evidence, whether it comes in forms of testimony, whether it comes in forms of notices of reliance, in order to support their case in chief. Following that, the applicant for the trademark, you if you've been served the notice of opposition, otherwise known as the defendant in this case, is going to have their opportunity to submit their evidence. And finally, the plaintiff is going to have one more opportunity to submit evidence that could possibly rebut evidence submitted by the defendant. On paper, the trial period is going to take about 3.5 months, but mileage may vary on that because these disputes never run the same way every single time. Following the trial period, we'll get to the briefing stage. This is where each case is going to present their summation or their argument as to why they should win in this opposition. Similar to the trial phase, the plaintiff is going to go first. The plaintiff is going to submit their brief to the TTAB, and then that's also going to go to the defendant, who can then review it as they're putting together their brief. The defendant's brief then gets submitted after the plaintiff's brief, and finally, again, the plaintiff is going to get one more opportunity to submit a rebuttal brief following the defendant's submission. These 3 briefs together will form the entire presentation to the TTAB for decision. At this point, the parties can be done. However, either party can submit a request for oral argument. Now, this oral argument is not meant to be some grandiose presentation in front of a jury. This is going to be an argument in front of 3 judges of the TTAB. It's rare that trademark cases like this make it all the way to oral argument. I've done it, and it is quite interesting to see the difference between arguing in front of the TTAB and arguing in front of a typical court. At this point, it's more of an opportunity for the judges to ask you questions to clarify their understanding of the case and answer the questions that they need to know in order to make the decision. So once you're past the briefings and oral argument stage, you'll receive the final decision from the TTAB. And this decision is generally going to have one of 3 outcomes. The first outcome is that the opposition is dismissed, in which case your trademark gets to proceed past this opposition. A second outcome is that the opposition could be sustained, and that means that the opposer wins and the trademark can't proceed to registration. And finally, I had a third category because of course there's other ways that these can be resolved, but ultimately the goal if you're opposing a trademark is to get it sustained, and the goal if you're defending your trademark is to get it dismissed. If you do not like the decision that the TTAB made, you are able to appeal it either to the Court of Appeals for the Federal Circuit or to a district court. So that's how the proceeding works. If you take it all the way through, it'll go in those 6 phases. Not every opposition makes it through all those 6 phases, of course. Typically, you'll see them drop off at the bridge between each phase. You'll see a lot of oppositions that drop off during the pleading stage, whether that's due to non-response by the defendant or by the defendant winning on a motion to dismiss or otherwise settling out. Next, you'll see a tranche drop off during discovery. Sometimes parties, when they finally see the evidence that is involved, they realize that, maybe the opposition isn't going to work for them. It's not worth fighting. At which point they'll settle it out and get the proceeding dismissed. Finally, you'll see some drop off at the summary judgment phase if a summary judgment motion was filed and granted for a particular party. Usually if they go past there, if they go into trial, they'll probably make it through trial because parties at this point have the opportunity to submit their evidence, and they're pretty well committed to going through to a final decision from the TTAB at this point. And that's where we come to the key tip that I want to give during this video, and that is how to resolve the TTAB proceeding for your business. The first step that you need to do is you need to talk to an attorney who's experienced with TTAB proceedings, because you need to build a strategy early. You need to decide what the end state that you want to see this proceeding go to is. If you're the opposer, presumably you've already done this. But if you're the defendant, you do need to figure out what the end state is, how much you're willing to fight, what you're willing to give up, and how you can build a plan to affect those goals. And that plan can take a variety of forms, because it's going to take into account your goals, your business, your resources, the opposer's business, the opposer's resources, and you need to decide how you want to fight the case, if you want to fight the case. You may decide that you just want to rebrand your company and avoid this proceeding altogether. That's of course an option. You may decide that you want to fight it. If there's a huge power differential between you and the opposer, it may on one hand be advantageous for you to come out swinging. On the other hand, it may be advantageous for you to sit back and let the proceeding run its course. And finally, of course, depending on your goals, it may be to your advantage to try to settle it. Whether settling it early on, as quickly as you can, whether waiting till we get some discovery and settling it then, these are all things that you need to talk about with your attorney at the very start of the case to determine what the goals are, what the expectations are, so that you can have an understanding of what needs to be committed to this TTAB opposition. Now, it's important to know that the same rules that we've talked about through here apply to cancellations as well, except in that case, the trademark application is not being opposed, but rather someone is trying to cancel a registered trademark. Ultimately, the proceedings are going to proceed the same way. The main difference is that if the trademark has been registered for a particular amount of time, certain arguments regarding its invalidity or reasons why it should be canceled are not available. I was actually able to argue one of these cases in front of the TTAB, which is rare to get to do that. The misnomer when you're thinking about attorneys is that they spend all their time in court arguing cases. That rarely happens. If you're litigating as an attorney, you're spending most of your time in discovery, where you're exchanging information and emails and communication back and forth with the other party to determine what the lay of the land looks like in the case. I was able to actually argue in front of the TTAB, and this was a live argument. And it was a great insight as to how the TTAB actually handles these cases. Because again, while the rules are similar to the federal rules, you're using the federal rules of civil procedure, the federal rules of evidence, the proceedings are different from arguing in federal court. And that's why it's important to understand the process and how this works. The other thing you need to do as part of your plan is you need to decide what kind of case that you want to present, because that's where you need to focus your evidence. It's very difficult to decide later on in the case, say in the trial phase, how you want your case to be presented if you do not have the evidence that you need to present that case. One more reason why it's important really on to decide on your strategy. And the final reason, and this is a big reason, there are a lot of deadlines in these proceedings. There are deadlines that start as soon as you receive that notice of opposition. There are deadlines throughout all 6 stages that you need to be on top of during a TTAB proceeding. So it's important to talk to your attorney and have an understanding of when those deadlines are as you're putting together your strategy for handling the case and as you're planning out how you're going to affect that strategy.